Good morning. Today is Tuesday, the 19th day of October. It's 10 a.m. and this is the Weber County Commission meeting. We welcome you here this morning. Our Pledge of Allegiance this morning will be led by Christy Bingham. I'll have the invocation, and our thought of the day will be given by Commissioner Frohr. We'll go to that point. Ms. Bingham? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Our Heavenly Father, as we open this commission meeting this morning, we're grateful for the opportunity to live in a free country. We're grateful for those persons and families that have paid such a sacrifice that we can enjoy our freedoms. We're grateful, Father in heaven, for the rules and constitution we live under and the divinity of it. We ask thee, Heavenly Father, to watch over us, bless those who are in attendance and those who will be joining online at a later time too, that truth and understanding will be felt. We're grateful for what we have, and we're grateful for so many of our bounties. We ask thee also to bless this nation and our county and those residents here, that we might all continue with the excitement and the goodness that's found here by so many. We love where we live. We're grateful for the moisture too that thou sent us. And these things we say in the Savior's name, Jesus Christ. Amen.
Amen. Mr. Chair, if I might.
Please.
So I think we all understand that the national bird that we see across the U.S. is the eagle. But I don't know if all of us know that the national mammal is actually the American bison. That was established in 2016. Now, I'm a little prejudiced to bison in a couple different ways. But I wanted to give us a little history. Since October 30th will be the upcoming bison roundup on Antelope Island for our good neighbors in Davis County to the south. That herd is approximately 700. And every year they round up that herd wherever they are on the island, take them into pens, inoculate them, and then they sell off about 200 so that they can keep that herd at a manageable level for the amount of vegetation on that island of between 5 to 550. I've actually done that before. I encourage people to go out and look at that. It's an amazing experience. Bison are, quite frankly, an amazing animal, and it's great to have them as a national mammal. The history of American bison, some of us are aware of. Back in the 1500 year, there was about 30 to 60 million. They had estimated 30 to 60 million bison in North America. By 1884, late 1800s in the North America, there was less than 500 due to a lot of factors. Well, there wasn't really management at that point in time, but overhunting in a lot of areas. And in the late 1800s, Teddy Roosevelt actually went to what they called the Dakota Territory to hunt bison. Well, there wasn't a lot of bison back in that time, and I think he figured that out. So he went back to New York at that point in time and set up what they called the American Bison Society in 1905. Because of that, we now have 3 genetically pure herds. One of those is Antelope Island. Genetically pure means they don't have any bovine blood. The largest of those herds we get to see is we probably mostly seen in Yellowstone Park, which is just under 5,000 bison. That's on largest herd on public lands. I think that there are some private herds that are bigger than that. But anyway, a little history about American bison. Get out and look at the Roundup from your automobiles. I'd advise people not to get too close to bison, as they are a wild animal, but they're amazing, and I'm proud to say that they represent America as our national mammal. That's my thought.
Wonderful. Let's, we both know the answer to this, but we, in Weber County, we're a little more closely related to the bison, and we actually, we have a show and a sale. Will you just take that moment to put a pitch in for that, will you?
Yeah, that's the Western Bison Association has been having their annual auction here for a period of time. Chair Harvey may know longer than I have, but a number of years, I know 10 years for sure, that they come in from the Western United States and actually sell animals from calves to cows to young bulls. And it's a great auction. It's great to see all those people come from all parts of the West. I would hope that they continue, because the auction of both cows and bison has gone more to the internet, and it's great to see them. So if you haven't experienced the auction, I'd encourage you to go to the Golden Spike Arena first Saturday in December
At noon. I'd be out there. The preview's at 9:30. It's awesome. It's an awesome show. To see him live and to just see him move, it's really cool. Okay, commissioners, let's move on to item E, Echo. Our consent items today will be the following. It's a request for approval of warrants 4493 through and including 4520, and 462 799 through and including 462 945 and 121, in the amount of $2,088,525.87. Item 2 is a request for approval of purchase orders in the amount of $63,612.91. Item 3 is a request for approval of minutes for the meeting held on October 12th, 2021. Item 4 is a request for approval of new business licenses. Item 5 is request to set a public hearing for November 23rd, 2021 at 6 p.m. to consider a Weber County property tax increase of 4.5% or $2,163,000 to fund flood control projects and library system improvements. Item 6 is a request from the Weber County Sheriff's Office for approval to transfer tools to Weber County Property Management. State Code 24-3-103 allows this when evidence is no longer needed for evidence. The rightful owner is unable to be found and the owner is not entitled to lawfully possess the property. Commissioners, questions on any of the consent items 1 through and including 6?
Motion to approve consent items.
We have a motion
Second.
and a second. I'll hear that vote in just a moment after we hear Mr. Hatch. Go ahead.
Thank you, Mr. Chair.
Thank you.
The county issued 7 purchase orders this week for $64,000. Just over half of that amount, or $35,000, was for the Recreation Department to purchase a mower and a tractor. 16% or $10,000 is for the IT purchase of software for Economic Development Department. As far as checks go, we issued 176 checks for $2.1 million. 24% of that amount, or $495,000, is for the transfer station, which is almost exclusively for disposal fees. We had 2 items at 14%. $301,000 was for corridor preservation relating to 450 East in North Ogden, as well as 5500 West in Hooper. And then $291,000 was for road construction, primarily at Rulon White Boulevard in Pleasant View, but also at 20th Street in Ogden. 13% or $279,000 is for the Golden Spike Event Center. The bulk of that is for the repaving of the parking lot. There is also work, some ventilation modifications to the riding arena. And then 5% or $105,000 is for the jail to purchase food, a network switch, and building maintenance and improvements.
Thank you, Mr. Hatch. Commissioners, if that doesn't prod any more questions, we'll place that motion for vote. All in favor?
Aye.
Aye.
Aye, motion carries. We'll now move on to item F, or our action items today. The first item we'll hear today was a request for approval of a resolution of the County Commissioners of Weber County appointing members to the Weber County Veterans Advisory Board. Christy Bingham.
Good morning, Commissioners.
Good morning.
I'm here there were 4 vacancies to be filled for the Veterans Advisory Committee, the Weber County Veterans Advisory Committee, excuse me, and So we are asking to reappoint Daniel Scheck, Jerry Inglesby, Frank Mon, and Terry Scow as to be reappointed. Jerry Inglesby is actually stepping in for Dennis Howland. He has stepped down. So we'd like to thank him for his service on the board. But do you have any questions?
Don't have any questions. I believe, Commissioner Jenkins, this particular board is in your portfolio.
It is.
This one.
I have no problems or questions here. You know, you get to a point where some individuals stop coming. So you have to turn them through to keep fresh energy on the board.
Yeah, unfortunately, due to the COVID pandemic, they didn't meet all of 2020, so a lot of their appointments.
They're all retired.
Yeah, retired and.
Sure.
No, I'm prepared to make that motion.
If there's no questions from you, Commissioner Farrar, I'll entertain that motion.
I'd make a motion that we approve resolution number
43-2021.
43-2021.
2-1. Yeah. Have a motion for resolution 43-2021.
Second?
And a second to place that motion for vote. Mr. Brandt?
Okay, roll call vote for resolution 43-2021. Commissioner Farrar.
Aye.
Commissioner Jenkins.
Aye.
Chairman Harvey.
Aye. Motion carries. Thank you.
Yep, thank you.
Commissioners, this next item, we've had some emails, we've seen some emails, we've taken some telephone calls, and we'll take a little public comment on this particular action item, as I believe some of the people in the audience would like to speak to this issue. I'll explain that in just a few moments. But the item number 2 is a request for approval of Weber County policy, expressive activity restrictions, and the final reading of an ordinance of the County Commissioners of Weber County authorizing restrictions on expressive activity. Mr. Crockett, I'll turn that time over to you after just as I understand it, we're just codifying what's already in the law and it's part of the state statute. Is that correct?
Correct, and I'll go through and I'll explain where that statute
I'd like you
came
to do
from.
that now, please.
And I hope everyone can understand me. I went to the dentist this morning. My entire bottom lip is numb, so I'm not having a stroke. So.
Okay.
But I will take some time to explain this because I see that we have members of the public here and who are interested in this item. And then also we've received several emails and telephone calls, and I've spoken with some individuals in the community who have expressed concerns and also had questions as to what this policy and ordinance does, why it came about, and what the implications of that is going to be. And so I'm happy to do that. And also, after this meeting, depending whatever the commission decides to do, if there are questions, you are more than welcome to come up and talk to me afterwards. I would be happy to set up a time or see if I can answer them then. But I wanted to start off by first starting with what is one of our fundamental rights as citizens of the United States, and that is codified in the Bill of Rights, which is the very first one is the First Amendment. And in a simple paragraph, it says, and simple but yet one of the most important paragraphs I personally think ever written, in what truly stands us apart as citizens of this great country. And also, I mean, in many, has been a model for many other countries throughout the world. It states, Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble and to petition the government for redress of grievances. Now, that simple paragraph has yielded scores and scores of opinions from courts throughout the entire country. The Supreme Court has given many opinions interpreting what that means and applying it to specific situations. There are classes in law school that are dedicated to this one paragraph. to find out what the Supreme Court has said and what it means today and how it's applicable to us. And so with that, I'd actually like to read some statements from the U.S. Supreme Court outlining what is known as the public forum doctrine, which is what this policy is. And it goes through and outlines the different types of speech citizens can engage in when they are on public grounds. And so there are three specific types of, there's public forums, there are limited public forums, and there are non-public forums. And I'll go over each of those. First, we'll start with the public forums. It says, the Supreme Court stated, and this was in the case Perry Education Association versus Perry Local Educators Association from 1983. The justices state, in places which by long tradition or by government fiat have been devoted to assembly and debate, the rights of the state to limit expressive activity are sharply circumscribed. At one end of the spectrum are streets and parks which have immemorially been held in trust for the use of the public, and time out of mind have been used for purposes of assembly, communicating thoughts between citizens and discussing public questions. In these quintessential public forums, the government may not prohibit all communicative activity. For the state to enforce a content-based exclusion, it must show that its regulation is necessary to serve a compelling state interest and that it is narrowly drawn to achieve an end. The state may also enforce regulations of the time, place, and manner of expression which are content neutral, are narrowly tailored to serve a significant government interest, and leave open ample alternative channels of communication. So an example of this would be if there was a protest in front of the WEBER Center. We've actually seen that happen. We don't restrict those. We'll see in the policy that if it interferes with traffic or it presents a public safety issue, that would be a significant governmental interest where they can come in and they can remedy that situation. But for the most part, people can protest. We see that happen all over the country. That is a public forum. A limited public forum, the Supreme Court states, a second category consists of public property which the state has opened for use by the public as a place for expressive activity. The Constitution forbids a state to enforce certain exclusions from a forum generally open to the public, even if it was not required to create the forum in the first place. Although a state is not required to indefinitely retain the open character of the facility, as long as it does so, it is bound by the same standards as apply in a traditional public forum. Reasonable time, place, and manner regulations are permissible, and a content-based prohibition must be narrowly drawn to effectuate a compelling state interest. So I wanted to give some examples of where you would see this. Down at the legislature, when they're in session, there are times where it's appropriate for members of the public to give comment. That would be when a particular bill is being heard and it's listed on their agenda. But there are other times where the legislators are voting on matters they are discussing in their meetings, and public comment is not allowed. It would not. You cannot just go into the Senate chambers or the House, take the floor and say whatever you want while they're conducting business. The government has an interest in conducting that business, so it's one of those time, place, and manner restrictions. Another example of where you would see this is in a courthouse. The court has a significant government interest in administering the law. If there is a criminal case, a judge would not allow that courtroom to be a traditional public forum where people could come in and say whatever they want. They would be at risk of being held in contempt. And that is the interest of protecting the defendant's due process rights and administering fair justice. So the third one, and these are the non-public forums. Public property, which is not by tradition or designation a forum for public communication, is governed by different standards. We have recognized that the First Amendment does not guarantee access to property simply because it is owned or controlled by the government. In addition to time, place, and manner regulations, the state may reserve the forum for its intended purposes, communicative or otherwise, as long as the regulation on speech is reasonable and not an effort to suppress expression merely because public officials oppose the speaker's view. As we have stated on several occasions, the state, no less than a private owner of property has power to preserve the property under its control for the use to which it is lawfully dedicated. So that is what our United States Supreme Court has stated on that matter. So if the government is going to impose these time, place, and manner restrictions, it has to be content neutral. It can't be related to a specific viewpoint that a person has, and there has to be reasonable opportunities to still express, for a citizen to come in and express their interest on a particular matter. The Utah State Legislature, and part of the reason why you're doing this, is that they passed a new law which states that if a political subdivision, this is in Utah Code 1161-104, if a political subdivision imposes a generally applicable or individually applicable time, place, and manner restrictions on expressive activity on public grounds, the political subdivision shall ensure that the restriction is narrowly tailored to serve an important governmental interest, including public access to the public building, public safety, and protection of public property, is unrelated to the suppression of a particular message or the content of the expressive activity that the restriction addresses, and leaves open reasonable alternative means for the expressive activity. Now, in order to do this, the Utah State Legislature put in a requirement that requires counties and other political subdivisions to either implement those time, place, manner restrictions by ordinance, or adopt an ordinance that allows it to be done by policy or by practice. And so that's what we are doing today. We are codifying what has long existed in the law already. And last week we heard the ordinance, which, and I'll read I will wrap this up because I know I'm taking quite a long time, but it is important. One of the statements from the ordinance where it says, it is the intent of the Board of County Commissioners to promote and foster freedom of expression in the public space by balancing the First Amendment right to freedom of speech and assembly within the county's right and responsibility to provide services to the public and to maintain a level of decorum that is appropriate for public business. This ordinance allows the passing of a policy. This is on for a second reading today. The policy, which I have had every single one of my attorneys review in depth, and we have had many, many discussions discussing the implications of this policy. And the attorneys in my office, I would say every single one of them are huge proponents of the First Amendment. And it was with that in mind as we went over this policy. The policy, which and I believe there's copies which are online that are attached to the agenda. It provides definitions of what is expressive activity, what is a public forum, such as public roads, public sidewalks that would run adjacent to roads, limited public forums, such as lawns and other open areas not otherwise restricted, and public meeting rooms like this room, rooms over at the library, which are often places that can be reserved for citizen gathering, and then non-public forums, the interior of a public building, entries and walkways leading from parking areas to entries and parking areas, and then restricted areas, such as over at the sheriff's office. I mean, there's a significant public governmental interest in restricting access to where inmates are incarcerated. The policy is individuals or groups are permitted to the free exercise of expressive activity in public forums, areas, so long as they do not impede the flow of pedestrian or vehicular traffic or violate any federal, state, or local laws. The non-public forums, individuals or groups are permitted to access non-public forum areas when those areas are open to the public, but are not permitted to the free exercise of expressive activity in the non-public forum areas. And an example of that would be in the clerk auditor's office. It's a very high traffic area where people are coming in to get marriage license, passport applications. To hold a protest in there would significantly interfere with a governmental process and interfere with the rights of people who are trying to access other governmental services. Use of limited public forums, which would be an example would be in here, when individuals or groups are permitted to the free exercise of expressive activity in limited public forum areas, they are subject to the following content-neutral time, place, and manner restrictions. Availability, that we can put hour restrictions, time restrictions. They can't just, doesn't operate 24 hours a day. when individuals are permitted to engage in expressive activities in limited public forum areas, they must abide by the following requirements. Expressive activity must not violate any federal, state, local, or other applicable law, interfere with the activities or rights of other persons or the operations of the county, solicit or directly contact county patrons, disrupt others' use and enjoyment of a public building inside or outside the building, cause injury to persons or property or threaten to cause such injury, use or threaten violence or force or encourage others to use or threaten violence or force, obstruct entrances or exits to the buildings, obstruct vehicular or pedestrian traffic, represent a threat to public safety, include camping or the use of temporary shelters, affix items to any permanent structures, light any material on fire, utilize any amplification device, or attract a crowd larger than the occupant limitations that the location can safely contain. The county may also enact additional restrictions as may be specified in other county policies, such as rules of order that govern boards and such as the county commission. And then there's restricted speech. You cannot use speech that incites imminent lawless action, speech that triggers a violent response, true threats of violence, obscenity, or child pornography. Those are all things that are not protected by the First Amendment and are absolutely clear through Supreme Court precedent. That is an overview of the policy, but I thought it was worth taking the time to explain the law behind the policy and how it came about and what this policy actually says. And I believe what is contained in there really doesn't come as a surprise of how we act when we enter into public facilities and how public business is conducted.
Thank you, Mr. Crockett. That's a great explanation. We appreciate that and very well thought out. And I appreciate you keeping our First Amendment in check. Very much so. Commissioners, we're gonna take some public comment on this. In order to do that, I need a motion to adjourn our commission meeting and go into a public hearing. Is there a motion for that or no?
I don't think it's necessary.
Okay.
I think you can just
If
go
it's
ahead
not
and take public
necessary, I
comment.
won't do it.
You can
Then, well, here's what we'll do. By the show of hands, are there those in the audience? I'm just talking about this matter only. I know that there are 3 other items on the agenda. We're not going to take comments on those items, but on this particular motion or on this particular item, item number 2, are there those in the audience that would like to address the commission? By the show of hands. Great. Please keep your hands up if you would, please, just for a moment. We'll hear from 3 of you. Ma'am in the first row, we'll hear from you. Ma'am up there, right there, we'll hear from you, and right here in the front on this. Then I'll hear from Jennifer, I'll hear from you. Very good. You'll have 3 minutes apiece to share. We ask that you respect the time clock of others. We'll also ask that you address the commission, not the audience. Please keep your comments to us. It's not a time for questions. We're not answering questions here, just for your time to comment, if you would. So let's go in that order. Go ahead. Please state your name and the city from where you are. If you'll just make sure we have that on our minutes. Thank you.
My name is Rebecca Champion. I came here.
Sorry, say that again in the mic.
I'm sorry. My name is Rebecca Champion, and I just have a statement. If the law was already in effect, why do you have to qualify it? That's all I have to say. Thank you.
Thank you. Please hold your applause.
Good morning, gentlemen. My name is Victoria Dortzbach. I'm an inhabitant of Ogden, Utah, and I appreciate all of you for what you do. Now, I'm going to be speaking quite frankly today, and a lot is in my heart and mind. So you see, I woke up to a lot of things a couple of years ago, and the concern I've had is the way that we have, as a public, as people, let government do things to the point where our rights have been trampled on. But as soon as I woke up to that, I realized, oh, our rights come from God. Our unalienable rights come from God. And what that means is a couple of things. So a couple of things is, number one, you guys all took oaths of office to defend the Constitution, the 17 1789 Constitution and the Bill of Rights that was ratified in 1791. And what that means is that we can hold you accountable personally if you violate that. And there is a ton of law, Supreme Court law, American jurisprudence law that backs that up. And as I've talked to you before, in September of 2020, there are Title 42, Section 1983 lawsuits available that people can take the ball and run with if they so choose. And so what happens is, I'll go ahead and read this to you. The Supreme Court, here's a Supreme Court case that I have. Justice Brennan, commentary on the New York Times versus Sullivan case of 1964. The public debate should be against the background of a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. Now, I myself personally have not had vehement and caustic attacks on you. I did get up because I did read in the procedures of the county in May that we can address you as people to any item, any matter of business that the county we the people can address that. And to me, the fraud of government is the biggest problem of all. And that needs to be addressed. And if you don't address it, we the people have the power to do so. Because here's an American Jurisprudence, Volume 16, the second edition, Section 256. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. The general rule is that an unconstitutional statute, whether federal or state, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose, since unconstitutionality dates from the time of its enactment, and not merely from the date of the decision so branding it. An unconstitutional law in legal contemplation is not inoperative as if it had never been passed. So I am completely involved as a woman in the way that my local government is functioning and the way my state government is functioning. And attorneys, they turn people's rights over, and that is not someone I would listen to. I would listen to we the people, sirs. Thank you.
Thank you, Victoria. Next one.
Good morning, gentlemen.
Hold that mic down, Jennifer.
Oh, yeah, I'm a shorty.
That's
Here we
okay.
go. Listen, the first thing I want to say here...
State your name and city, please.
Yeah, I'm Jennifer, and I live in South Ogden. The first thing I want to say to you, gentlemen, is that I'm not here to make war on you. I certainly don't agree with these things that you're considering today, but I do want to point out a few things, okay? And the first is that the language of this Chapter 188 that Mr. Crockett or the county is signing as the legislation from the state that authorizes this policy and this ordinance, there's nothing compulsory in the language, okay, which means that you are completely enacting these voluntarily. And I just want to tell you that I find it completely unethical. Completely unethical. Now, I put some questions to Mr. Crockett because I see this act that you're taking in considering this policy and ordinance as an ex post facto, which means that you're enacting this to silence us because you don't agree with our messaging. And our messaging has been very specific to the topic of COVID. And I just want to illustrate that there have been numerous times when you have met with Mr. Cohen, you've had open meetings, but no comment. And then when we come to these meetings to address what we heard Mr. Cohen say, you did not allow us to comment at that time either. And so to us, because that's to us seems censoring, okay? When we come to you consistently about a message and we consistently see that you meet with Brian Cohen and there are issues that we take with the things that he reports to you, these are the things that we want to address to you, and you have silenced us. And so I have asked Mr. Crockett if he can prove that this is not an ex post facto action. He hasn't responded to that. And I apologize. I need to gather my thoughts for a second. So I think that's where I'm going to stop, is because I consider this unethical, and I do see this as your attempt to censor our messaging. And I don't agree with that. And I absolutely want decorum just as much as you guys, but I see that you have made the conditions right You've made the conditions right for things to devolve by not allowing us to comment to the things that are in our hearts. Now, we don't want to sit here and berate you, okay? We specifically have issues with things that Brian Cohen has said, the things that he reports to you as fact, for which we contest, okay? And these things are important to us. And I just want to say in closing is that as the legislative body, okay, as it is here, as it is at the state capitol, our power is with the legislature. And this has been proven time and again through American jurisprudence and other sources. And what that means is that this is a court of record, which means that what we say is available for everybody. Okay, and that's why these monitors are important. Not that we want to hijack them. Thank you. I will end now. But we don't want to hijack the meetings, but we want to talk to you and get our point across. And that's it. Thank you.
Thank you. Okay, thank you very much for those comments. Appreciate that. Chris, would you, Mr. Crockett, will you take a moment? The first comment had to do with why are we codifying? Would you answer that question? Why are we codifying?
Sure. And so, the Supreme Court and courts throughout the land have recognized that these time, place, manner restrictions are constitutional, but the Utah Supreme Court implemented a new requirement, and this is the one that Jennifer was referring to, and that's Utah Code 1161-104. And it says a political subdivision may not impose a generally applicable time, place, and manner restriction on expressive activity on public grounds unless the political subdivision imposes the restriction by ordinance or adopts an ordinance to guide the adoption by policy or practice of restrictions on expressive activity on public grounds, and adopts by policy or practice the restriction in accordance with the ordinance described in subsection 2BI, and this is an important part, and with the constitutional safeguards described in subsection 1, which is has to be narrowly tailored, unrelated to the suppression of a particular message, and leaves open reasonable alternative means for the expressive activity.
Very good, thank you. Again, Mr. Crockett, Ms. Stortzback commented that they have the right to address items of business. Does that include any time, any place, anywhere, any manner? How does that work again?
No, if it's content neutral, you can have those time, place, manner restrictions, but there has to be reasonable means for the public still to address you. We have public hearings that where the public can come in and comments. For example, on the agenda, we just gave notice that there's a potential tax increase. By law, you're going to have to take public comment on that. It's a significant issue where the commissioners, the law has built in a provision that requires them to listen to that. In example, in a court setting, you have the right to file lawsuits where you can go and have your grievances redressed. You can petition your government for redress. And so there are a number of opportunities. You could have a protest out on public sidewalks in front of the building to express your First Amendment rights. So it just has to be narrowly tailored, and there has to be reasonable means leave open reasonable alternative means for the expressive activity.
Very good. Very good. And then also, Ms. Pennington, did I say that correctly? Yes. Ms. Pennington brought up Brian Cowan. That's okay. I had a heart with Cohen. I'm thinking, who's Cohen? Like, I was thinking of the comedian at late night TV, Cowan. That's for Brian Cowan. She talked about an ex post factor, unethical and an ex post factor. Can you speak to that? I don't know what that is.
No, I mean, I wasn't quite sure exactly what she was Ms. Pennington was meaning by that. But as far as implementing this law, I mean, we followed the requirements of Weber County Ordinance, which is to first present it for a first reading, and then we're having the second reading right now. And if that passes, we're adopting the policy. So we're following the standard procedure for enacting this ordinance and policy.
Very good. Thank you. Yeah, go ahead, Commissioner.
The question I have is the constitutionality of this. That's questioned, and I think it's very important. I mean, you addressed that in your opening remarks, but could you talk about that again?
Sure. I mean, we start with the very first thing we start with is the language of the Constitution itself, and then it turns to how have courts interpreted that, because they're the ones charged under the Constitution for interpreting the law. And so we go through Supreme Court precedent, which Ms. Dorsback referenced a very important Supreme Court case, one that is often referenced, New York Times versus Sullivan. But we go through and we look at that Supreme Court precedent to find out what the courts have said on a particular topic that we are addressing right now, and to find out how it's going to apply if we implement that, and we do, what types of risks are there. So this is why this one was of significant importance, that I turned this over to all of my attorneys, and I gave them weeks and weeks, and we've roundtabled this to come up with different scenarios as to, well, what if this happens? Would that be constitutional? What if this happens? Is this allowed? And so we really vetted it, and we had several of our attorneys push back really hard to make sure that we came up with a policy that was indeed meets the intent of the Constitution and would withstand scrutiny. So it's been very, very thoroughly vetted.
Commissioner, does that answer your question?
That does.
Any others?
So it was mentioned when Mr. Cowan gives us a report on COVID, which we take weekly from him. We normally don't open that to a debate at that time because we're taking a report. Are we required to open that to a debate or have public comment on a report?
No. No, in the administration of business, I mean, you could be hearing that in your executive capacity. If the law will state when you have to take public comment, and they will call it a public hearing. For example, if you pass a land use ordinance, those are ones that generate significant public interest. The law requires that you actually have a public hearing on that. A tax increase, you have public hearings on that. But a work session or a report that you're receiving to get an update on the most recent COVID-19 numbers from the health director is not one of those instances.
Excuse me. Well, go ahead, and then I'll wait.
I was going to say, so in our case, our insurer, Utah County Indemnity Pool, they actually recommend that we don't take public comment in some non-public hearing circumstances because, as example this morning, we had 3 oppose this, but we didn't have anybody equally on the other side who did not oppose this. And so they have been given what would you call it? They've been giving an advantage over the other one just because the fact that nobody was here to represent them.
And that is one of the reasons why we have noticing requirements to go on our agenda to let the public know what topics are going to be addressed by a particular public body on that day. USIP, Utah County Indemnity Pool, they do not take in general public comment just as at the end of an agenda. There are ways that they have set up to have public comment happen, and to let the members of the audience know here, we are actively working on that. We are reviewing our rules of procedure and to establish a process for times when the commissioners feel that it's appropriate to take public comment, that we can allow that to happen. And that's forthcoming.
See, so by our action, we actually make the field uneven. And we have a liability if we do that. And so we have to be very careful about when we allow public comment and when we don't because of the liability we take upon ourselves if we don't make it a level playing field.
Sure.
And you see recommendations in other areas of the law where this happens. The former property ombudsman, Brett Bateman, I heard him say several times in administrative land use cases, he strongly recommended to not take public comment during those because it would introduce the potential for public clamor to get in and interfere with an individual's due process rights. And so it's really, there is time and place for it to happen.
For Mr. Crockett, for people who wanted to address Mr. Cowan or address the WEBER Morgan Health Department, or do they have a time, a place for that?
So they meet once a month. I believe it's on the fourth Monday of the month. And they are governed by a separate board. And you can contact Mr. Cowan or Dr. Frank Brown, the chair of the board. And we have Commissioner Froer, who is a member of the Board of Health, communicating with them. There's times where they will take public comment on their items that they're entertaining and get public input on that. So, yeah, there's opportunities for that.
Okay, very good. Thank you. Commissioner Froer, any comments?
Yes, thank you, Mr. Chair. First off, I want to thank Mr. Crockett and his attorneys for the hard work and diligence put into this. This is not an easy subject, but with his report, I think it's clear we're clearly within constitutional boundaries. We're clearly authorized by state statute to put an ordinance in place. And I believe that's what we're doing. And he mentioned in his comments the legislative process at the state. We're the legislative body for this county. And having some experience at the legislative body at the state, he's exactly correct. When the business of the people was discussed on the floor of the House chamber, and I know it was the same in the Senate, public was not allowed in to make any comments. In fact, no members of the public, unless they had authorization, were even allowed through the doors of the chamber. They did have the right to stand outside the doors and protest and make contact with their representative or senator, which they did on a daily basis. Sometimes there was as many as 300 or 400 people or more in the Capitol. So I look at our duties as a legislative body of Weber County, and our duties are directed toward doing the people's business, just like we do at the state and they do at the federal level. And it's our duty, in my opinion, to give the public the opportunity to weigh in on the agenda items, just like we do at the legislature, like they do at the legislature during a public meeting, which is a public hearing that's noticed on an agenda. Those people have to be recognized by the chair. And as Commissioner Jenkins said, in order to make it fair, typically what happens in those committee meetings, there's 3 or 4 based upon time limits, and there are very strict time limits on those committees. 3 or 4 are allowed to speak in favor, 3 or 4 are allowed to speak in opposition. And that's how that is done. I'm in favor, and we've had this discussion as we move forward, for the public to have the opportunity on agenda items to weigh in on those that may be appropriate. But it does, again, we owe it to the public to conduct the people's business in a fair and efficient and a timely manner. And I believe that's what this ordinance does, without unduly infringing on freedom of speech, constitutional issues, and their ability to contact their elected representatives, which is us, either through email, personal visits, phone calls. We're not cutting that off whatsoever, and I'd encourage those people to do that. So that's my comments, Mr. Chair.
Thank you very much, Commissioner. You know, for me, I like that we're following the law. I like that we're being efficient. I love the efficiency of the Weber County Corporation right now. And I say corporation because we are doing the business of Weber County government, and it's going very well. Very, very well. And the employees, I'm very grateful for what you've done to make us such. I want to give people the right to speak. However, I don't want a group or an individual to come in and filibuster or take over a meeting. That's not right, especially on subjects that don't pertain to the county business. And we have a responsibility to our county citizens to be efficient, to cover those things, just like you said, Commissioner, for those things that pertain to the business at hand. And so there is a time and a place and a manner in which we take care of things. So with that, Commissioners, is there any other discussion? Hearing none, I'll entertain a motion.
Mr. Chair, I'd make the motion that we approve ordinance number is a
2021-26.
2021-26.
Have a motion.
On the Authorizing restrictions on time, place, and manner, as we've outlined.
Have a motion
Second.
and a second. I'll place that motion for vote. All in favor?
Aye? Oops.
Roll call.
Roll call. Thank you, Craig.
Okay, roll call vote for ordinance 2021-26. Commissioner Frohr,
Aye.
Commissioner Jenkins,
Aye.
Chairman Harvey.
Aye. Motion carries. Thank you. Item number 3, Commissioners, is a request for approval of an ordinance of the County Commissioners of Weber County updating Section 6-4-5, restraining animals and leash law, prescribing a monetary fine for animal attacks, bites, etc., resulting in injury. Our Director of the Animal Shelter, Chad Averett. Chad, welcome.
Thank you,
Doing a great
Commissioner.
job out there.
Appreciate
Wonderful.
that. It's not just me, it's my
You got a
team.
great staff.
Great staff, great team there that we have.
Go ahead and tell us about this, please.
Sure. I'm here to present an ordinance of Weber County amending Section 6-4-5 of the Weber County Code of Ordinances. Currently, there are no prescribed monetary fines for violations of Section 6-4-5. And in an effort to further deter persons from allowing animals to run at large or to further cause harm or injury to persons or animals, Weber County Animal Services desires to implement a monetary fine for violations of Section 6-4-5, as herein described, of the Weber County Code of Ordinances to amend as follows. Under Section 6-4-5, the current language states restraining animals and leash law. We would like to amend that to improper restraint and attacks. Under this Section 6-4-5, subsection A, basically states that what the leash law is, that it is unlawful for any person owning or having the custody, possession, or control of any animal to either negligently or with specific intent improperly restrain or fence the animal in a manner that allows the animal to escape or to run at large. Dogs are to be restrained on a proper leash at all times on the public right-of-way and in public places. To further, with this amendment, we added 2 more subsections. Subsection B states, in addition to the penalties under Section 6-7-3, any person owning or having the custody, possession, or control of an animal that attacks, bites, chases, or threatens any person, domestic animal, or any species of wildlife shall be issued a citation in the amount of $200. In subsection C, in addition to the penalties under Section 6-7-3, any person owning or having the custody, possession, or control of an animal that attacks, bites, chases, or threatens any person that causes that person to suffer injury shall be issued a citation in the amount of $250. Basically, these 2 subsections that we're asking is currently there is no law, like it stated further, to implement any monetary value to these. This will hopefully deter and make the community and the citizens of Weber County to be more responsible in the handling of their animals. Do you have any questions?
Any questions for Mr. Averett? Commissioner Frohr, this is in your portfolio.
No questions. Let me take that back. I just want to clarify. So basically, this puts a monetary damage in place in conjunction with our existing leash laws. So if an animal bites, attacks, there's a monetary responsibility as well as some type of possibly civil liability. Is that correct?
Yes and no.
Okay.
To answer that question, specifically under the current the ordinance, there was just a leash law violation. There was no monetary value to that. It was just under 6-7-3, which is a Class B misdemeanor. With this new amendment, it adds a monetary fine to that. So it includes animal attack, which the county has never had that ordinance before, and it's not consistent with other counties in the state of Utah as well as other cities who do have that ordinance that has that monetary value to it. And it's a huge factor in deterring citizens who own their animals to be more responsible for that. So that's why we decided to implement this, so we actually cite it specifically if that animal does cause harm or attacks a person, wildlife, or another animal, we can add that monetary value to it.
Okay. So one last question. So if in the event that somebody's not leasing their animal, does that institute a monetary damage if they're not on a lease and they should be? So it does that as well?
Yes.
Okay. No other questions.
Very good. Thank you. Mr. Jenkins?
Question I have, it says chase or threatens. The other day I walked up to a home. Actually, I was walking on the sidewalk. I didn't walk up to the home. I walked by the home. And a dog come out front and barked, one bark at me and growled just a ditch. And then he stopped and he just walked up to the side of me as I was walking by. And almost like he wanted to follow me, and I shoot him back because I didn't want him to follow me down the road. But in that case, he threatened, I guess, because he barked at me, and he didn't chase me, but he come right out to me. Would that be, how far do you take this? Because, it's hard to define those things when it gets to that point.
Yes. There's no specific, there's two subset categories that we cite people when we investigate a possible animal attack. Those two are either provoked or unprovoked. In your situation there, that would be kind of hard because the animal is confined within its boundaries, legal rights on its private property. It has a barrier between you and that animal. However, if you're standing in front of that residence and yelling at the dog or throwing water at it or sticking your fingers in there or throwing sticks at it, that would be considered provoked. You're provoking that animal to act the way it is. Now, as an animal control officer, we can go in there and investigate that. According to your statement and possible witness statements, we can issue a citation at that point for you provoking that animal to the owner. Now, that comes into the deputy or the attorney's office, whether that, when it goes to court, if they plead not guilty, it goes to court, and it'd be to either a jury or a judge to determine that factor. Well, does it meet the criteria of this section? Of this section. And if so, they'll take action accordingly. Unprovoked is the ones we really focus on. Same scenario, you're walking in front of that gate and that animal, because the gate's not high enough and it's a larger dog, it jumps the fence and it attacks you, bites you. Well, that's an unprovoked attack. You're minding your own business. You're on a private or public right of way. That animal jumps the barrier, attacks you, then we issue a citation for that. Now, the owner could possibly, there's all kinds of scenarios and different things they can go into that the animal owner can go into. But again, those are the basic things, provoked or unprovoked.
Thank you. I understand why they're here with this. We've recently had this attack of that little gal by those two dogs, and man, they just tore into that little gal. And that was through a hole in the fence, I think, is how they got out. And so I understand that, but I don't know. Normally I like these to come before us before we get to this point, so we have a chance to reason, walk through them, make sure we're doing the right thing. In this case, it didn't happen.
What other questions do you have any more? Would you like to sit on it a little while? What are your thoughts?
I would
here?
like to sit on it a little while.
And
Unless you're wanting to push it forward.
this is in your portfolio. What are your thoughts there, Commissioner Floor?
I'm comfortable moving this to the next agenda item. I would just say that owning animals of any sort carries with it responsibility to make sure that those animals don't infringe upon somebody else's right, including their health. So in general, I support this, even though I come from a background with Commissioner Jenkins. I think undue regulation sometimes just causes other issues, but I'm not opposed to, if it's okay with Mr. Averitt, to carry this forward so we can have maybe a little more detailed discussion of this.
Should we hold then? Is that what you're saying?
I'd make a motion to hold.
It's also a first reading as well.
Oh, there we go. That answers that.
So we could, obviously, first reading, so we're not taking any formal action to approve
Correct.
this. Okay. Well, if I could amend my motion then to approve
Please.
the first reading with the comment that we'd like additional clarification over the next week or so to discuss this with Mr. Averitt and his team.
I'd second that. No, it's first reading.
And before I call for the motion, just Mr. Averitt, if you'd just contact staff and get on the agenda, work agenda, and then we'll have a little clarification, 15, 20 minutes, just to have any other questions. That'd be sufficient.
Yes.
Thank you. Appreciate that. We'll hold that. All in favor to hold?
Aye.
Aye. Motion carries. Thank you. Commissioners, we need to go back and revisit item number 2 one other thing that takes place on item 2. I just was notified by legal.
So, Mr. Chair,
Yes.
you just said, we just voted to hold it, yet the motion was to approve it.
That's right.
I'm sorry. I'm my mistake.
Okay.
Motion was to approve this first reading.
May I do that again? I'll make a motion to approve the first reading. All in favor?
Aye.
Aye.
Aye. Very good. Mr. Brandt, is that clear? Clear? Sorry. Thanks for holding me accountable there. Appreciate it. Commissioners, on the second item, we were successful in passing the policy, but that's separate from the ordinance. I need a motion for the ordinance on item number 2.
Policy.
No, I think, Mr. Chair, if I might, I think we passed the ordinance, but did not pass the policy.
We still need to pass the policy
That's
separate
correct.
from the ordinance. Thank you very much.
And Mr. Chair, I'd make a motion to approve the policy as written by Mr. Crockett.
I'll second that.
Okay, I have a motion and a second. Now, does that require a roll call vote?
No, this is just a policy.
Motion to approve the policy. All in favor?
Aye.
Aye.
Aye, motion carries. Item number 4 is a request for approval of the Legacy Mountain Estates LLC subdivision improvement agreement and financial guarantee in the amount of $5,213,968. I'll read again. $5,213,968. Tammy ate a lot. You're not Steve Burton.
No, I've got a
Much-
little less facial hair today.
Much more. Boy, what a nice change that is. Steve, just telling you.
Commissioners, you recall this subdivision came before you for final approval back on October 5th. This is one of the steps towards recording the subdivision. This would be your standard improvement guarantee agreement and associated escrow. Do you have any questions for me?
Questions, Commissioners, for Ms. Adelot regarding Legacy Mountain?
Mr. Chair, just one question. So
Please.
we passed that with a checklist. Where are we with that checklist?
We went over the checklist with Commissioner Harvey. Everything has been completed to planning and engineering satisfaction.
Great.
How about that?
Good job. Thank you.
Report.
Great report. So with that, then I'll entertain a motion.
I'd move to approve the Legacy Mountain Estates LLC subdivision improvement agreement as presented by Ms. Elliott in the amount of $5,213,968.
I'll second that.
We have a motion and a second. I'll place that motion for vote. All in favor?
Aye.
Aye.
Aye. Motion carries. Thank you. Item number 5 is a request for approval of a resolution. The County Commissioners of Weber County approving and accepting deed or irrevocable conservation open space easement. This is exciting. Mr. Burton. I knew you'd make your way
That's
here one
right.
day.
I'm just going to display on the screen for you the parcel on which this easement applies really quick here. It's not as great of quality as I would have liked, but I think you're able to recognize where this is at. So, Commissioners, I'm excited to present to you today a resolution that, if approved, would grant the county an easement, an open space preservation easement on 877 acres. This is a requirement of the DRR1 zoning ordinance for the resort zoning at Powder Mountain. I believe you're familiar with this easement, but this is a requirement of the development agreement and the zoning that was approved a few years ago up at Powder Mountain. And there's a requirement to dedicate open space throughout the development. So every few years we'll see some of this open space be dedicated. So today we're talking about 877 acres. There's also an easement granted to the Ogden Valley Land Trust, and the trust and the county will, the intent is for the trust and the county to preserve this area as open space. Part of this easement describes some of the uses that are allowed. It says passive public uses like hiking. There can be skiing done. There can be biking along trails. It also specifies the time of year that it can be done. So specifically, it states May 1st to October 31st. the public is allowed on the property for these recreational uses. Public's also allowed on the property during the winter months with the consent of the owner. In this case, it's SMHG, the developer at Powder Mountain.
Is hunting allowed on that, Steve?
The agreement does specify hunting. And I believe it says under certain circumstances, probably in conjunction with state law. Let me see if I can find that for you here. I'm looking at, if you have it, I'm on page 11. I'm just going to go through a few of these pages before I maybe ask the owners also here, and they might be able to point me better to where it talks about hunting, but I know hunting, it does talk about hunting as one of these uses. Okay, so I'm looking at page 13 of this agreement, Commissioners, and there's a paragraph 3 on here. It says, hunting within the purview of the allowable purposes of the existing and or any future cooperative wildlife management unit, or CWMU, as controlled by grantor, in this case is SMHG, the owner, and authorized by the Utah Division of Wildlife Resources, so long as such actions will not materially impair the conservation values under the conservation easement. Grantees, which are the county and the Ogden Valley Land Trust, sorry, no, they're not. Yes, they are. Agrees to cooperate with the grantor and to consent to any amendments to the existing CWMU and the implementation of any new, revised, or amended or replacement CMWU under existing regulations or similar regulations that may be adopted by any government or regulatory agency that governs the property in the future. So it does sound like hunting's currently it's something that's allowed.
It's allowed under CWMU, but open hunting is not allowed. The CWMU is a pay-for-use cooperative wildlife management unit, and so it's not open for public use.
Right, specifically for hunting, that's correct.
That doesn't make me happy.
And the first part of it said by permission. I think the dates were in there for public use. And then after the 31st of October, it said by permission from the owner.
That's correct.
I think
it isn't. Oh, good.
Commissioners, if you have any questions, I believe is it Ann Winston, right?
I'm happy to.
Would you like to address that, please?
It's been a couple of years, I think, since.
Nice to see you again, Ann.
I'm happy to answer any questions. I think the intent is to maintain the consistent access to hunting that currently exists on the property. So I'm not that well familiar with the hunting regulations in the CMWU. But that is the intent, is to not change anything from the current use.
Well, the reason this gets my attention is because the section of property above this, that whole section is owned by the county.
Yeah, there is a parcel that is owned by the county.
right.
That's not this parcel.
So what ends
This
up
doesn't-
happening here is somebody's going to take a rifle to go up there and hunt, and they're going to have to walk all the way through this property before they can actually hunt.
And part of that, you see the easement going up through there. That's fairly well defined in the picture we see here.
This doesn't change anything from the current use.
So is that in a CWMU today?
Currently, my understanding is that is how it is. The hunting is administered.
My understanding is in that CWMU right now. I think it is in the
Yeah,
CME, right?
that's my understanding.
Yeah.
I'm speaking a little out of turn because I don't have that much familiarity with it, but that the purpose of this dedication is to conform to or comply with the municipal code and the DRR1 zoning that requires a dedication of open space to mitigate against the development. So, and it's a little bit more complicated than this formula, but it ends up being really an acre per acre. So we've platted 436 acres to date. So the requirement is that we dedicate 436 acres to open space so that that land can't be developed. This parcel is 877 acres, so we're actually dedicating significant acreage in excess of what's currently required, but in anticipation that we'll continue to develop. And this has taken years for us to negotiate and a lot of time, both from the county, the Ogden Valley Land Trust, and with our internal team. And so we're taking the opportunity to dedicate the full 877 acres of this parcel so that we don't need to revisit this until, many years in the future if we get to the point where we actually dedicate that much acreage. But the intent is to maintain the land without development. The hunting, this was actually added in just to make sure that we didn't interfere with the CWMU rights that were currently existed. So that was the intent of adding this to the easement. Hunting is not otherwise required to be addressed in the ordinance.
Mr. Burton, what's the recommendation from staff?
We recommend that you approve the resolution.
Thank you.
Yep.
Thank
Are
you.
there any other questions that I can address?
Commissioners, any questions for Ms. Winston?
Not for Ms. Winston, but may I make a comment?
Please, yes, sir.
So, once again, this is a circumstance where something should have come before us from the Planning Commission in our work meeting to talk about.
It did.
Specifically?
Yeah, about 3 weeks ago.
I do remember this now. So, what ends up happening here, when this was brought to us, I have recollection of that now, but we didn't talk about CWMU on that. And we didn't go through the detail that this ordinance is right now. So what ends up going to happen here now is they'll put a gate up to the front of that, and on that gate they're going to put a sign on there, and it'll say that this is a CWMU unit, hunting by permission only or by permit. And in essence, they shut off access to an entire section of land behind them, which is public property. You see what I mean?
I think there's still some room for negotiation if you want to see if there's a way to allow the access.
If I could address that?
Sure.
There's no intent to cut off any current public access. That's not at all
Understand,
permitted.
but
That's not at all permitted.
by law, you have to have a sign up there that shows it's a CWMU.
Are you aware of that? I'm not aware. I would think, so
Yeah,
we're not
I am
actually-
aware,
We're
and
not
you do have to have that
No, I mean,
posted.
if there's a sign there or not, I'm not aware if there's a sign, but we're not
Yeah.
changing anything from the existing use.
No,
So there's
I understand
existing
that.
access,
I understand
to the
that.
county's
My
parcel.
point is, when you have that sign up there or any notification,
Mm-hmm.
instantly, a respectful hunter says, oh, I can't go in there because that's a CWMU and I haven't bought a permit for it. And I understand that. That's what I do. But then, in effect, it's almost like we need to make a requirement that says you are permitted to go through this and hunt the property behind it.
We can address that in this.
Yeah.
If there's signage that's required, then we can have signage saying that this geographical area is in the CWMU and any hunting needs to comply with that. But there's public access available to the county's parcel. We have no objection to that.
And would you be willing to modify what you have just existing here to maybe show that easement, especially to access the Weber County property that's beyond that or the piece that's to the north?
Yeah,
Sections
sure.
to
I mean,
the north?
I'd have to look at the kind of legal description and what the access is, but there's no intent to prohibit access to the
Thank you.
county parcel. And
Yeah.
all of this language, and
Understand
just
that.
to comment on, Steve made a comment regarding kind of summer and winter usage. We're just concerned in the winter about avalanche terrain. So that's what
That's a great
that's meant
point,
to
too.
address. It's just to protect the public from getting into avalanche.
That's heavy avalanche area up in there.
So
Heavy.
that's the only reason why there's a distinction between summer and winter usage.
Yeah.
The other thing is that there's winter use, there's passive ski recreation permitted on this parcel once it's dedicated. There is a cat track that was excluded from that where we don't currently use cat access, but we reserve the right to provide cat access to the adjacent parcel, which will not be in this. So part of the reason why there's a discussion about summer versus winter is that it restricts our ability to use motorized like cats in summer months. So it's really not restricting. It's restricting Summit's use of the property, how it can use it in the summer versus the winter, because there's a very specific permission to use cats in the winter. There's no intent to change anything with respect to access for hunting from the existing usage.
You've done really well. You've put a lot of time and effort and this is a long time. If we could just get that last piece so that we can access our piece up there on the top.
Sure, I think it'd be like one sentence probably added to the document.
I'd like to recognize a member of our legal team, Cortland Erickson, right now, and have him come up and speak to that for just a second.
He's coming up, Mr. Chair.
Okay.
Steve, I'm sorry. I just didn't get into the depth of this. And it wasn't until I'm sitting up here today going through it and I hit the hunting.
Hey, listen,
No reason to apologize. Yeah.
I had an impression on that too and didn't think about it in our work session either. So that's why I feel impressed to say something here too. I support that. Go ahead, Cortland.
I was also involved with Ms. Winston and the attorney for the land trust in this, and it's unclear to me what you're asking to be clarified, because the way it is right now, it does not prohibit the access, as has been stated, to the county's parcel in any way. Right. And I'm not a hunter, so I may be totally wrong about this, but I would think hunters who are responsible know what their rights are and they take advantage of those. They will research this. They will know that they can get to the county's parcel through this, and that will be perfectly fine. And I do not see anything in this agreement that is before you that needs to be changed to make sure that happens. It does not eliminate or restrict that right in any way. But is there something that you're asking specifically needs to be clarified to make that? Well, and I guess the second point would be, are you asking us to change the paper document?
No, for me, I'm visual. Okay. And so for me, I can clearly see the easement coming up through that one portion there that would be on the first third or the left-hand third going up that draw or that canyon. I believe it's called Cold. Is it Cold? It's not Cold Creek. It's Wolf Creek Canyon. Yeah. It's called Wolf Creek Canyon. Mm-hmm. And so, okay, Commissioner.
So by state law, when you put your property into a CWMU, you have to post that so that people are aware that that is in a cooperative wildlife management area unit. And so what ends up happening as a hunter, you go by that. When you approach those, you say, okay, I'm now in the CWMU. I realize I have to buy a permit to hunt on that. And so I didn't buy a permit. I'm going to pass it by. But generally speaking, nobody knows that the unit behind this is open to hunting. And so just by the fact of misinformation or no information, nobody knows that they can walk through there and hunt the unit behind it.
If I could address that.
Mm-hmm. Please, Mike. Yeah.
We would be happy to add some language to the existing or required signage for the CWMU to state that public access to the county's parcel is not restricted by that
just
CWMU.
something simple like that.
That would satisfy me.
Is that? I mean, we have
and then
no
maybe
problem with that.
on the back end when they leave your property, it says you're now are accessing public property.
It's remote.
Oh, it's very remote.
It's very remote, and
We've been up there.
Yeah, and frankly, I don't know how many people would be impacted by this, because my understanding is that, it's challenging to access the property, regardless of who owns it. But we're happy to provide whatever signage makes sense given the usage. That's not problematic.
I'm fine with that.
Cortland, is that to help you with clarification?
That makes more sense to me than amending the document that's in front of you.
Yeah, I agree.
I'm fine with that.
So then I'll entertain a motion that has that language in it.
All right, I'd make a motion that we approve the resolution. You'll give me that number?
27. I believe it's 27, isn't it?
No, this is a resolution 44-2021.
44.
44-2021. That.
Oh, sure.
Approving the deed and irrevocable conservation open space and easement as presented to us today with the with the verbiage that we are going to include, or the attachment to this, that there will be a sign on the right-of-way through there that says just something simple, right-of-way to county property on the north side, or something like that. I don't care, just as long as people understand that they have the right to trespass that right-of-way. There's no more than a trail, I agree, that's all it is. And they can walk up there, and then when they get to the back property, just something says you are now on Weber County property.
The back or the top of the property.
Top, the north end, whatever you want to call it.
Makes sense.
Great.
Clear. Cortland, I'm going to want a nod from you. Okay, great. Commissioner
Thanks.
Farrar, is there a second?
I'll second that with a comment.
Please.
So I think we need to recognize that right now it is in the CWMU, which also already has a sign on that property.
That's true.
So it's not a matter of a new sign going up. That's already there. So I support the motion, but I support the action by Summit and the land trust to put this in, actually more acreage than was required, by almost double as I understand it.
That's right.
For open space with public access, which is very important because a lot of times we see easements created without public access. So to me, that's the key to it. And I think that gives us the opportunity for anybody that is willing to take that hike, which is not an easy hike, by the way, to get to that Weber County site. So I second that.
We have a motion and a second. Ms. Winston, let me just tell you thank you so much for the work that you've done, and you've gone above and beyond. The Summit's gone above and beyond for this area. It still gives us the opportunity for the public to access the public property there behind it. We appreciate that effort. With that, Mr. Brandt, I'll place that motion in your hands for vote.
Okay, roll call vote for resolution 44-2021. Commissioner Farrar.
Aye.
Commissioner Jenkins.
Aye.
Chairman Harvey.
Aye. Motion carries. Thank you. Item G, commissioners or commissioners' comments. Hearing none, I'll entertain a motion for item H.
Move to adjourn.
Second.
Motion is second. All in favor?
Aye.
Aye. Motion carries. Thank you.